This is Law Bytes, a podcast with Michael Geist.
Think the contents of your smartphone are private? Well, think again if you plan to head to the States this summer. Civil liberties groups are warning that Canadian border guards have powers you might find surprising.
It isn't every day that a Senate committee examines legislation and makes notable changes against the wishes of the government. But that's what happened last month as a Senate committee reviewed Bill S7, which raised significant privacy concerns regarding the legal standard for searches of digital devices at the border. A chorus of opposition, led by Senator Paula Simons, led to changes in the bill, with the chair of the committee acknowledging that, quote, "We did not have one witness except the minister and the officials say that the new standard was a good idea." University of Calgary law professor Michael Nesbitt, who teaches and researches in the areas of criminal and national security law, appeared before the committee to argue against the government's proposed approach. He joins the podcast to talk about the bill, the changes at the Senate, and what lies ahead as the bill moves to the House of Commons in the fall. Michael, thanks so much for joining me on the podcast.
It's a real pleasure to be here. Thank you.
Okay, I'm glad you've come on. You know, Bill S7 largely flew below the public's radar screen. I mean, in some sense, that's not surprising. Not many Senate bills attract a lot of attention. But I think at this moment, as we record it, provides a really interesting case study on a government bill that raised privacy concerns, didn't get a lot of attention. And then suddenly you had a Senate committee persuaded, and in part by you, as you were one of the people that appeared before the committee, that there was a problem in need of fixing. I think it's fair to say that that doesn't happen every day. And for those of us concerned with any number of different bills head to the Senate, provides a little bit of a ray of hope. So I'd like to use this podcast to talk a bit about what happened and then also focus on whether there's some lingering concerns with the bill, given that this unusually for bills started in the Senate, it will head to the House in the fall. Why don't we start more broadly, though, with a bit of background on what happens when travelers are at the border, assuming that they can get their passports sorted out. When they cross the border, what powers does the CBSA have when it comes to searching digital devices? You know, are there differences between digital devices, let's say, and our physical luggage?
Yeah, and this is that question gets to where all of this is coming from. So the powers at the border more generally depend on sort of, you know, in a way, who you are, right? Are you a traveler? Are you picking someone up? You know, where are you standing in the building? But it also depends on what they're searching. And then you have different grounds that are required to be met in order to justify different types of searches. What had been happening, at least up until these recent cases, which brought about this Senate hearing, was digital devices were being treated as quote unquote goods under Section 2 of the Customs Act, where it was defined. And so this is old legislation, and it's based primarily on case law from the 1980s. So old case law, old legislation. And so digital devices were essentially being treated like your suitcase. So, we decide something's fishy. We want to search someone, can sort of perhaps do a pat down, ask them a bunch of questions, and we can search their digital devices. So that's the essence of what had been happening at the border, I suppose, until now.
How do they address digital devices? You know, there's often talk for people looking for advice about what to do when they cross the border. And sometimes you hear about the notion of shutting off the internet on your device as a means of limiting potential search solely to what is on the device itself rather than what's accessible from the device. Is that a legal requirement that arises from the CBSA? If not, is it something that we could see included in the legislation? How does that play out?
Yeah, and this is one of the things we can get into with respect to how the bill that is still going through, the House now, could be improved. What they've done is they have internal requirements within the CBSA. So their internal requirements have sort of said, as a matter of practice or policy, we're going to turn off your network access when we're searching those devices. That's not in the Customs Act. It's not law. You know, whether there are other requirements, again, is just down to policy, which is made internally without public consultation, without democratic debate. Not saying that's always bad, but that's how it's happening on what are actually some very big issues, particularly when you get to the topic we're discussing now, which is digital devices, which are hold so much information, personal information.
Sure. No, and certainly it's not just the information that we put on them directly, but of course, as we move to cloud-based services, and we're at the use of cloud-based services, it's everything that we can access through those devices that becomes so relevant. Now you mentioned old case law, and the impetus for this bill was the Canfield case. Can you talk a bit about that case and how it was addressed? I know it comes out of Alberta.
Yeah. So many of us who sort of watch this kind of stuff in the law have been frankly waiting for this type of case for some time. I mean, I've had students for the last 5 or 10 years writing on how odd it is that your digital devices can be searched as though they were a piece of luggage, right? As though those would have similar things in them. So no surprise here. So what happens is we get, it's actually two individuals, Mr. Canfield and Mr. Townsend, and they're caught separately at the border, but the cases are combined because the subject matter is very similar, and the constitutional challenge is essentially the same, and that is they're both caught with child pornography at the border. The Canfield case in particular, which is the fact scenario we're talking about, was there was concern that he was a sex tourist traveling to Cuba, and that as a result, he might have child pornography on his digital devices. So when we say digital devices, that could be your phone, that could be your computer, it could be an iPad, tablet of some kind. So he gets to the border, and the officer does the usual, the guy's coming into the country. He notices that he's a little too verbose in his answers. He starts to get a little sweaty, and they decide they're going to send him for sort of secondary screening. And they get into secondary screening and ask him, do you have child pornography on your cell phone? He says, maybe, I don't know. Later says yes. So they take his cell phone. They ask him for his password. This is an interesting one, too, from the criminal law perspective, which is where I normally deal, because a police officer asks you for your password. You say, good luck with that. But, CBSA internal rules say we're not allowed to ask you for your password for the apps you're in, as I understand it, but we're allowed to ask you for the password of your phone. So they get into your phone and they find child pornography both on Mr. Canfield and Mr. Townsend's digital devices. And so we end up with this constitutional challenge, which is we're not denying that the crime has been committed. What we're saying is you had no right to discover the crime in the first place. You no right to the way you did search the phones. And the lower court here in Alberta says, no, it's fine. We have this case from 1988 that says, goods are different. This is like a suitcase, no problem. Gets to the Alberta Court of Appeal and they say, no, this is, your digital devices do not look anything like a suitcase. They go through the long line of Supreme Court cases we now have, which that case, but all sorts of private information, right, which is on your phone, your banking apps, photos with your family, accounting documents if you're a lawyer, solicitor, client documents possibly at the border that you'd be worried about if you're a doctor, client files, all sorts of stuff, right? So they say, no, there's a difference. And, it's one thing to say at the border because there's a reduced expectation of privacy, understandably so, right? It's a border. We need security. People are worried about airplane security and all that sort of stuff getting into the country or meeting our international obligations. So there's a reduced expectation of privacy. But look, that doesn't change the fact that there has to be some standard by which, for a digital device, you are articulating the justification for the search. And so they say, and as we understand the legislation, that, that there's no mention of digital device in the legislation. So if you're treating it as goods, then we're going to essentially strike down this as, part of the goods under Section 99 of the Customs Act. And so what you have is then essentially, at least in Alberta, you have striking down this piece of the legislation, which means who knows how you can search digital devices in Alberta. So what they do is the very common thing is, as it happens in law, which is sort of they say, you got about a year and a half, I forget what it was exactly, to figure this out, government, at which time, our ruling will essentially come into effect, right? So you can fix this by legislation. That actually passed. That time limit was up and didn't get renewed, which put increased impetus on for a bill to sort of clarify what's happening here. So that I think that's fair summary.
Yeah, absolutely. So it's a great background on sort of what led the government to move in the area. It wasn't that they necessarily put this in their electoral platform or anything like that. Rather, they had a case that essentially forced them to act, even if they took a bit more time than the court had wanted to see. So that leads us to Bill S7. What does the government do in response in that bill?
Yeah, so the government, I mean, this is an interesting one, just procedurally, right? Because they go back to court and says, no, don't worry, the government is acting. We just need a little more time. They just haven't quite figured it out yet. And the court says, well, we don't really see anything in the works. What they don't say is what is in the works is an independent senator has put forth a bill, which I just think is, it never came up in the case law, but I thought it was interesting, right? Because what you're essentially saying is independent senator legislation is actually government legislation. That's actually what this is, right? That's sort of an admission of that fact. But nevertheless, that's, how everyone has treated it without comment. So I suppose we have at least some independent senators are clearly, we may as well just call them what they are, whatever party they're in, right? So this is a liberal senator essentially who puts forth legislation, and the legislation is pretty simple. There's a bunch of little fixes, sort of making sure that legislation is consistent across different pieces that will refer back to the relevant sections that we'll have to change, all that sort of stuff. But essentially what they do is they introduce a brand new standard. They say, if you have a reasonable general concern as a border officer, then you can search the digital devices. And that's really where, and again, credit here to, Senator Paula Simons in particular for really making this a national issue by speaking out, writing articles on it to try to get the public involved in a way that some of the rest of us probably can't do given our positions. She just, she's a louder voice and a bigger audience. And so she really brought it, I think, to the fore, to the public consciousness, to the extent it didn't reach the public consciousness, which is what the heck does reasonable where'd you come up with this standard? Like, why is that your solution?
You're right. And Senator Simons has appeared on this podcast in the past, and she's involved in so many really important digital issues. Why don't we talk about the different standards that are out there, and then sort of you could provide some insight, if there is any, on what the government had to say about what this new standard would mean. So I know familiar standards would include reasonable belief or reasonable suspicion. Can you talk a bit about those standards, and do we have a sense of why the government didn't try to implement in this bill one of the known standards where there is a fair amount of case law involved, and instead went with this entirely new one?
Sure. I'll give you the really short, punchy answer, and then I'll explain it a little bit. And the short, punchy answer is, in law, we have two standards usually. If you're going to have a standard, which is reasonable suspicion or reasonable grounds to suspect, they're often used interchangeably, or you have reasonable and probable grounds or reasonable grounds to believe. They're well known under the Customs Act. They're well known under criminal law. They're well known in the court system, fully understood. Lots of case law explain what they mean. We'll get into a sec what they mean in sort of a sentence each, but really clear, right? Lots to go on. Reasonable general concern no one's ever heard of before. Why did they go this route? We have no idea. They honestly didn't stand up and justify it. There was no definition given in the proposed legislation. There was no definition given publicly. There were, at the Senate hearings, there was no definition given. There was no real explanation. It was sort of implied that it was just a different standard than the other two, and a different standard was needed. It's hard to imagine what that different standard would be without going the step further and saying what you're really talking about is you want a lower standard than reasonable grounds to suspect. But the government seemed unwilling, or the bureaucrat, whoever was responsible for this, seemed unwilling to come out and sort of explain, if it wasn't a lower standard, then why bother? And if it was a lower standard, let's admit it's a lower standard and then have that open discussion. So in essence, we have a brand new standard that we have no idea what it meant. That was the proposed. Reasonable grounds to suspect is, I think there's a case called R versus Stairs recently from the Supreme Court, and I think it explains it really well, because it gives you insight into the fact that this really isn't that high a standard to begin with, right? So it's not, when we're looking at reasonable grounds to suspect, we're not talking about the super high standard for searches that would have totally obstructed border guards from doing their jobs, or at least seen from the outside, unless there's more there that hasn't been publicly divulged in terms of what has to happen at the border. But Stare says reasonable grounds to suspect really requires only a constellation of objectively discernible facts assessed against the totality of the circumstances. In other words, can you point to some objective evidence, some sort of facts that are specific to the individual and the broader context that would lead you to suspect that maybe there might be, in this case, child pornography on the phone? I actually, rereading the case for this podcast, I'm pretty sure they would have had reasonable grounds to suspect if the border guard had articulated it properly. If this had been the standard, I still think they would have, they certainly could have met it fairly easily. There's also a higher reasonable grounds to believe standard. That's not really implicated here because that's not what the legislation has been changed to. The more common one if they want to do a search of your body, like a strip search at the border, it's reasonable grounds to suspect. If they want to open your mail, if you're sending mail across the border, it's reasonable grounds to suspect. So super common, used throughout the Customs Act, used in case law for border things, used in sort of similar circumstances to digital devices, right? Something more personal, like something approaching a strip search for your mail rather than your baggage, that sort of thing.
Okay, so well-established standards, principles that were already out there. I think you already mentioned it, but just I suppose reiterate. What were the concerns with the government coming out with sort of just an entirely new standard where there is no background, and what, if any, defense did the government provide for it?
Yeah, we had all sorts of great submissions if people want to look them up. I think a lot of them are online. The Privacy Commissioner offered some, Canadian Federation of Law Societies, a number of activist groups. I'll tell you the one I started with, which is, I'm just a professor who follows this. I'm not a particular activist in any regard. But my concern was, if you're going to come up with a new standard, not divulge what it means, you're talking about 5 to 10 years of litigation. Right. So your first concern is we have complete uncertainty for the next half decade to a decade at the border, which is bad for security and the border guards, and is bad for the privacy rights of the individuals and travelers, Canadians and non-Canadians, who are crossing the border, who don't know what the rights are at the border. So when you have clear standards, why introduce this uncertainty and cost? That's millions of dollars of public funds going towards litigation to resolve this conundrum. And at the end of the day, what are you going to end up with? You're going to end up with something that says it can't be reasonable general concern in the way that I would intuitively understand that, because the concern can't be purely general. It's got to be at least somewhat specific to the individual. And if it's got to be at least somewhat specific to the individual, that starts to sound like a constellation of contextual factors, both general and specific, that might lead you to suspect that maybe something is being done that's illegal here. In other words, reasonable grounds to suspect, right? So save yourself the time and the money and the uncertainty and the possible rights violations and the possible, security concerns, and just make the change in the first place. Alternatively, I guess if you got something else, if you got a definition, throw it out there so we all know and save ourselves these problems. That brings me to the next concern, which a number of people, I think, rightly argued. I did as well, but I think some put a greater emphasis on it, particularly those who are sort of involved in privacy activism. And that was, when you talk about a reasonable general concern, you're starting to talk about non-specific stuff that isn't necessarily associated with the individual. And that is going to bring in implicit biases and stereotypes, right? So that's where you get into the real concerns about, if it's not specific to the individual and the day or a specific threat, right? If you don't know, we're worried about a 22 to 25-year-old male coming through off this particular flight. If you're just saying that generally we have a concern at the border. Well, to be honest, and to be fair to the border guards, I always have a reasonable general concern at the border. We know criminality takes place. We know it's a really serious security threat if there is a breach, right? So there should be a reasonable general concern at all times, which means no standard at all. The alternative to no standard, essentially no standard at all, is it means something, but it means exactly what it says, a general concern, which makes you think, again, getting back to those implicit biases, but stereotypes, racial profiling, profiling on ethnicity or national background, all those sorts of things, right? You start to get worried about, because now you're talking about a border guard exercising their judgment based on nothing specifically articulable with respect to the individual, just their general concerns.
I think you've done a really nice job of highlighting not just the uncertainty that the proposed definition would have raised, but the harms that it could have raised as well. That it really was a lower standard that would attract a number of different concerns. Now, as we mentioned, you appeared before the committee, raised these concerns, and it was really part of what was essentially almost a unanimous chorus of experts who were uncomfortable with the approach. Indeed, I think the committee chair noted that the minister and government officials were basically the only ones defending the standard, and just about every witness they could find was critical of it. So the committee clearly was persuaded. How does it go about solving the issue?
Yeah, so this is great, right? As the sort of the big news story here is a bunch of senators who didn't necessarily fully understand the law were given a piece of legislation and a border context and did a really good job of looking to people from Ontario and Quebec and the East and the West and the prairies and all over Canada and said, what do you think? And then when they got basically unanimous feedback, they said, yeah, okay, that makes sense to us. And they made a change. So they changed the legislation from reasonable general concern to reasonable grounds to suspect, which is consistent with other areas of the Customs Act, as I said, with respect to strip searches and mail and a variety of other things as well. So a standard that's well understood, or should be well understood to the border guards, well understood to courts who are dealing with border, frankly, just well understood to courts because we deal with it daily, basically, in Canada on the criminal law side. It attaches to some sorts of production orders and all that sort of stuff too. So, so clear, well understood standard with a long history, and they make their place. It's the best of democracy in action in a way, right? It's thoughtful people making changes, but continuing to press ahead with legislation that was deemed needed. So, big credit to the senators for engaging so thoughtfully and then making what actually isn't that big a change, but is an important change.
Yeah, no, you're right. We don't hear a lot about these kinds of changes, and it's always gratifying when the community speaks up on the issue and they actually are heard. Sometimes you feel like you're speaking into a bit of a void. That, I guess, brings us to where we are now. So the committee made recommended these changes, or brought it out of committee with the change that you just described. Senate passes it. It goes on to the House. Now, with so much attention focused on specifically on that issue, did that in any way, in your view anyway, overlook some of the other potential issues or concerns that might have also been raised in the bill? So much focus on this standard issue. Were there other things that the bill could or should be doing that, as we think about the prospect of further reform and other hearings at the House level, we ought to start paying attention to?
Keep in mind, I'm a pedantic lawyer about this stuff, right? So I'm probably going to want more specifics than maybe the average person or politician, but absolutely. I mean, I don't fault anyone. I focus primarily on that issue because I thought it was the most important one. Because if we get that right, then the rest is it's not unimportant, but it's of lesser importance, right? That was the big issue in responding to the case and responding to the proposed legislation and creating certainty and protecting rights, and frankly, in protecting security. If you're just randomly focusing on general concerns, you're not focusing in on targets. So really important change. But there wasn't much in the legislation, which is what I started off saying, other than some technical changes and essentially this big issue. And so to me, the privacy commissioner, the Office of the Privacy Commissioner, did a really good job of raising some of the concerns, but I'll mention a few. And they are actually borne out by what CBSA appears to be doing, which is they're going to enact regulations. So lawfully enacted, they will be legally required, but they're going to be regulations that essentially say what the border officers have to do at the border when searching a cell phone. And so we get back to the initial issue, which is, but that's done internally, and it's great if they're doing consultations, but we don't know if they're going to listen to the consultations. They're not, it's going to be mostly bureaucrats, so they're not They're not required to. There isn't the public pressure to respond to public criticism or consultation in the way that there might be for an MP, where you can phone their office, or you can be in the front page of the Globe and Mail. And it looks like the regulations, from what we've seen, are pretty short. Like, they're essentially saying, turn off the network access, which we already knew they were doing. I mean, it's good to see it as sort of a legal requirement. And then, 6 or 7 other things that you're going to do while accessing the digital device. What's not in there is all sorts of stuff that I would expect to see if it was warranted activity in the criminal realm. And not because I'm saying it should be exactly the same as going and getting a warrant and. Saying we expect to see it when it's warranted in the criminal realm, simply because it just makes sense. The certain standards just make sense in terms of what you want to think about when you're accessing digital devices. So I can give you some examples of that. When you're accessing it, how are you accessing it? Are you using a program? Is the program you're going to use to access the material likely to delete content? Should a lawyer or doctor be concerned, or a business person be concerned, that important documents that they haven't uploaded yet are going to be deleted? Will it damage or corrupt files when they're accessing it? Are they accessing it just to see the material, or will it download it? If it's downloading it, will it be kept somewhere? If it's being kept, how long is it being kept for by CBSA? Who else has access to it? When can they access it? Well, what can be done with that information subsequently in terms of access, information sharing, and so on, right? None of this is addressed. And lest that seem too pedantic, and again, I say, some of my broader concerns probably would be seen that way to some. We just went through this 3 years ago with CSIS. We call it the new CSIS Act datasets regime. Now, it's a different context, and you're not going to want to do everything that was done there, but it addressed in the legislation all those issues which I just mentioned. We're seeing a similar thing with police forces across the country that they're having to go through. Sort of, how do you access information? What do you do with facial recognition technologies? Could they be used as part of the search? All sorts of questions that are just not in the regulations at all. And unfortunately haven't been discussed by Parliament, right? And so these are the kind of things, when it's this important, when it's this intrusive, that you would rather see open, honest debate with thoughtful politicians talking to those they reach out to. That'll be activist communities, it'll be academics, it'll be experts in the field, it'll be the border regularly, lawyers, doctors, business people, etc. Sort of looking at what they need and make a democratic decision where someone's accountable for the results. And so we know what all those rules are, because right now you're going to see a sort of a regulation appended to the Customs Act with 6 or 7 basic things with respect to what you're going to do when you're accessing those digital devices. And so one thing that I hope we'll see when it gets to the House, a little cynical on this one, I think we've had one change that be surprising to see a big revamp and then go through the process all again, especially because this has been a while coming already. As I said, we're already too late, according to the courts, twice over, sort of at this point. But yeah, there are a lot of remaining issues that I think, from a privacy perspective, you would definitely want to at least have the government thinking about in terms of how they access this.
Yeah, no, that's a great answer in terms of highlighting a lot of the missing aspects, in a sense, of the bill. I did one last substantive question. I did want to ask about oversight. You mentioned the interest that the Privacy Commissioner has expressed, and they were putting forward some issues. To what extent, what is the oversight system in this regime? I mean, you've identified all these potential holes. Can anyone take comfort in the oversight system, or is that yet another area that we could do better?
In general, it's been a huge area of concern for CBSA. Let me answer this piece by piece. The Privacy Commissioner, yes, absolutely could provide some. I mean, I think it was 5 years ago, 2017-ish, that the Privacy Commissioner did their last audit of CBSA. So certainly the Privacy Commissioner could do an audit of certain uses of this sort of thing. So there is a role for that office. That's a good thing. Having said that, it's sort of one person in one office with how many agencies in Canada? Anything that's covered by the Privacy Act. So there's a role for them, but not. You wouldn't put all your eggs in that basket, as it were. For national security stuff, if it rises to the level of national security, in the last 3 or 5 years, we have now the National Security Intelligence Review Agency, NSIRA, as well as, like, I guess it's still operating, the National Security Committee of Parliamentarians. They could both provide some sort of review, but it would be where it would touch on national security matters. And then what we traditionally have for the CBSA, which has been the problem, which is we've said for a long time the RCMP doesn't have enough review, because the only real review of the RCMP is sort of ministerial review if they choose to do it, and then complaints, right? So public complaints. CBSA, not only did it not have another type of review, it didn't even have a complaints procedure. And so we do have another bill right now, I think it's Bill C-20, which is offered to, and we'll see where it is, it's called an act establishing the Public Complaints and Review Commission and amending certain acts and statutory instruments. It will extend that RCMP complaints process to the CBSA. So 2 thumbs up for that. CBSA, now you could, well, if this is passed, you could complain, but it'll also extend that whole process to provide a review function. So if and when this new body comes into being, it will also, in addition to be able to do complaints from an individual who feels their digital device was unfairly searched or whatever, it will be able to review. So there is going to be some review. That's good, we think, but that's all contingent on Bill C-20 passing. And, again, things have been so slow. We're 2 years and still going on that one. And I haven't seen any indication it's going to make it through before summer. So we shall see on that one. But a little bit of hope, at least, in terms of review, especially when you put those sort of together, right? The national security and a new review commission and public complaints and the Office of the Privacy Commissioner audits.
Right. So, I mean, it sounds, I guess, to wrap up, that there's a good news story here, a significant concern with real privacy implications for people at the border. Community comes forward, Senate listens. But as we head to the House, it sounds like if we want to turn this into a great news story, so to speak, there's still quite a lot of additional work to be done.
Yeah, absolutely. For those who are interested in this, lots of things to think about, to reiterate, particularly with respect to what's happening with that information, how it's being stored, by whom, how it's being accessed, whether we want regulations doing this internally, which are going to be legally binding, but are going to be done as regulations, rather we want MPs to be engaging publicly and transparently.
Really interesting area, and one where let's hope the MPs who will presumably conduct some of the follow-on hearings in the fall are as receptive to getting advice as the senators were. The recent precedents suggest perhaps not, but hope springs eternal, I guess.
Yeah, exactly.
Yeah. Okay, Michael, thank you so much for joining me on the podcast.
It's been a real pleasure. Thank you.
That's the Law Bytes podcast for this week. If you have comments, suggestions, or other feedback, write to lawbytes@pobox.com. Follow the podcast on Twitter @LawBytesPod or Michael Geist @mgeist. You can download the latest episodes from my website at michaelgeist.ca or subscribe via RSS at Apple Podcast, Google, or Spotify. The Law Bytes podcast is produced by Gerardo Lebron Laboy. Music by the Laboy brothers, Gerardo and Jose Lebron Laboy. Credit information for the clips featured in this podcast can be found in the show notes for this episode at michaelgeist.ca. I'm Michael Geist. Thanks for listening, and see you next time.